This is The Law Show on CL 650. Now back to the show.
And although that's pain in my chest, I still wish you the best if I forget you. Now, baby,
Welcome back to The Law Show here on CIL 650. We're talking family law with Mark Perry and Anna Perry, founding partners of Westside Family Law. Just a curiosity question before we get into some of the details of high conflict resolution and conflict matters. We were talking during the break about the summertime and the summer doldrums and how everybody likes to put their feet up in the summer times. But, you know, for some businesses and for some areas of the economy, the summertime is the peak. Everybody's super busy. What is it like in family law? Is there a busy season, Mark? Is there do you have the dog days of summer in the family law business, or is it pretty constant year round?
I hold 29 years of doing this that the summer is a quieter time.
Okay.
Absolutely. September and January are the busy months. And that is, I've always understood to be, and dealing with clients in September and January, they've held it together for the summer.
Mm-hmm.
They have considered the step that they're now embarking upon. They're held it together for the Christmas season. You know, the kids have gone back to school, been away, gone away for university, and now is the time to move on the project of ending the relationship. That's my experience.
All right. Now, Anna has that expression on her face that suggests another type of experience. In the summertime, does your calendar vary dramatically in different seasons of the year, Anna?
Well, mine has been going skyrocketing since March with consultations, people who are immediately determined to separate.
Okay.
So there's that element. Sort of May, June, July, a little bit of August is also cohabitation agreements and prenuptial agreements. And then the other thing that we encounter is disputes about retirement, because the summer for in my practice, or my part of our practice, involves issues about support on retirement in addition to people separating.
Oh, okay. And over the summer is a time when people experience a little time off and start thinking, gosh, I could do more of this more often throughout the year. Perhaps I'll hang it up a little later on in the year. And retirement suddenly becomes a lot more front and center, doesn't it?
And it can be hotly litigated as well.
I'm sure it can. We'll talk about that. We talked earlier about a separation agreement. When a couple splits, and whether, Mark, it's been over the course of the summer that they've managed to get this strategy organized, and now in the fall we're going to do it, or whatever, is the usual first step, once the decision has been taken that we're going to go our separate ways, is that formalized in a separation agreement, Anna? Is that the usual step one?
Quite often there's a memorandum of understanding, and that can be either formal, something that they've had written up. Memorandums of understanding could be something a little bit less than a separation agreement. Quite often people will sit down at the kitchen table, have a confab over tea or wine, and write up their own terms.
Okay.
And that's just delightful. And then, of course, they come in the door, and yes, we do a separation agreement right out of the gate, and it's a lovely, pleasant experience for everybody, followed by a desk order divorce at some point if they're married. So
Okay.
the flip side of that, of course, is the family law files that we all hear about.
Right, exactly. But Mark, in many cases, do people call you up or send you an email going, okay, we've decided, we've had the talk, we have come to terms with the fact that our relationship is going to end. So we'd like to do it in somewhat adult, amicable, civilized fashion. Right. How do we start? Where do we go from here? Do people call you with that sort of fundamental advice?
Absolutely, on a regular basis. And the response to that might well be come in and see me, a conversation on the telephone, sometimes some email information. We have forms that people can track some of the key information that we're going to put into an agreement. So,
right.
I'm sending it to them. I'm talking them through the process, which may well be, or it's likely to be, that person's going to be my client. I'm going to prepare an agreement. and my understanding is it's going to be reasonable and amicable.
Right.
The agreement that I'm going to prepare, I'm going to encourage them to share with their spouse. Their spouse may or may not have a lawyer at that point in time.
Right.
But at the time of signing the agreement, I'm going to be strongly encouraging their spouse to have a lawyer review the agreement before they sign it.
Okay. And that's fair.
Yep.
And I would
Absolutely.
imagine ethically you would be probably compelled to suggest to the other party that you don't sign anything before you have your attorney have a look at it. It's only fair and reasonable.
Right.
Wanted to talk a little bit about a scenario in which there are no children. Is that but there's still high conflict. There's still that desire to punish. There's still emotions running rampant. But there aren't children, Anna. How much easier, from a sorting it all out perspective for the lawyers, is it to get even a hostile situation like that done where there are no children involved? Is it much easier?
Yes, definitely. You don't have the concern for the conflict and impacting the children.
Right.
So you can simply get to the nub of the matter. In high conflict cases, the best thing to do is try and shut the high conflict person down pretty early with restraining orders, some form of court order regulating their behavior. So
Right.
that could be a restraining order. It could be something that dictates that they don't come to the house or don't come to the other party's
Place of work.
workplace. Yeah, they
Oh,
don't.
okay.
They don't. So a no-go, no contact kind of order.
Okay.
And then there's other forms of orders for disclosure, because often high conflict is they refuse to provide documentation, or if they do, it's just a piece, noticeably the piece of the document that looks like it's in their favor. And you read behind the rest of the document and there's quite a bit more to the story. So document disclosure is an issue. But when you've got no children involved, it's tremendously different. It's much easier.
I'll bet it is, simply because, and as you were saying earlier, Mark, that a lot of the conflict, whether it's high conflict or otherwise, in any divorcing situation is about the children and custody arrangements and who gets what and all of those incredible details
Right.
that raising
Right.
a child involves.
Right.
So what happens, though, in a situation whereby you got the full menu, you've got children, you've got two working adults, so you've got two incomes, and then you try and sort it all out. When the relationship goes south, does the separation agreement, that initial agreement, okay, it's over, and so here are the rules around which we're going to try and move on. Does that original separation agreement include matters pertinent to the raising of the children?
Oh, absolutely.
Oh, it does then.
Yes.
Okay, all
yes,
right.
absolutely. It almost always does. It doesn't have to, but it
Okay.
almost always does.
All right.
I mean, it's been negotiated and sorted out and gone back and forth between maybe the lawyers for a long time.
Because somebody's going to get the house and somebody's going to have to go move out or
Sure.
get an apartment or whatever.
That's right.
And all of this, and this may, Anna, end up being disputed
That's right.
over a longer term. But there has to be some kind of initial agreement to begin the process, right? Or I guess some people just storm out and say, my lawyer will be in touch. And that's the end of that.
Sure.
Yes,
Well,
true.
sorry to interrupt,
No,
Anna,
no.
but the alternative to a separation agreement might be an interim court order.
Oh.
We were speaking earlier about my case with the 40 court applications.
Okay,
and Anna
right.
said some of those applications would be for court orders. That might be a judge saying in court, until there's a trial, meaning interim, this is the way things are going to work.
Okay.
You're going to leave, you're going to stay, the children are going to be with you during this period of time and with the other side during this period of time. This is the amount of spousal support, this is the amount of child support. That's an interim order.
And that the judge can impose those
Absolutely.
conditions just in the order of just in terms by way of keeping the thing moving
right.
forward.
Exactly.
That's right.
Okay.
Yeah.
Keeping the children fed
Exactly.
and hopefully assisting the parties to not make the children the subject of all their angst and conflict on a daily basis.
Right.
So the court's made an order, this is the way it's going to be, that has to be respected.
Okay, and once the judge issues that interim terms and conditions, do they occasionally, Anna, when they say, okay, here's how it's going to be until this matter is resolved, do they leave it open-ended? Do they still say, okay, now go work it out, work out the details,
absolutely.
But until the details have been resolved, this is how it's going to be? Is that pretty common?
Well, in high conflict cases, you're best off to have a fairly detailed order, because the high conflict person will find any leeway, any loophole, if you're not specific in the order. That's, for example, every Friday Johnny will be delivered at 5 p.m. at Toys R Us, and exchanges will be at Toys R Us,
Right.
for example. Otherwise, every Friday there will be a war about turning out, delivery exchange of Johnny.
Right.
It won't happen at 5. It won't happen at Toys R Us. It'll always change, which of course just drives the other party crazy, because they can't schedule their life. They don't know where they're supposed to pick up their child, etc. So the more specificity you can get into those orders, the better, because it really locks it down and reduces the conflict by reducing communication.
Talking conflicts here in family law matters. Our two guests are Mark Perry and Anna Perry, the founding partners of Westside Family Law, which is online at westsidefamilylaw.ca. If you'd like to have a look at their bios and meet some of their colleagues on their website, please do so while we take this following very quick time out.
There's more of the show still ahead. This is The Law Show on CIAL 650.